Good day to all. I'm Advocate Pradeep Shukla, practicing at Bombay since 49 years. Since I am also empaneled with 22 banks, so I feel this was a very important judgment for all the banks and financial institutions. And the little facts I will just narrate. The borrower had availed the credit facility against the mortgage of the property. Borrower was not able to maintain the account properly and it was declared NPA, and in execution of the right, the bank has given the notice under SARFAESI and took physical possession of the property, and ultimately the auction was declared. In the auction, purchaser paid 25% of the auction price. In the meantime, the borrower was really struggling and was trying in the DRT, DRAT, High Court, etc. to save the property, and the borrower kept on depositing money time to time with the bank. The auction purchaser was also trying to get the finance for the balance 75% payment, and he took around 15 months to pay the balance amount. But in this case, what had happened was the borrower in the meantime completed the total outstanding and paid the balance outstanding amount to the bank, and the auction purchaser also paid the balance amount to the bank. Now there was a rift between the what is the right things to do. Is the borrower is right? Can he get the property back? Or that the auction purchaser in whose favor the bank has confirmed the sale is proper or not. The matter went to the Madras High Court, and the High Court decided in favor of the borrower, and the confirmed sale was set aside. Against that, the auction purchaser went to Supreme Court. In the Supreme Court also the matter was vehemently argued. What has happened in the Supreme Court has observed. I'll just better for the benefit of everybody read exactly what the Supreme Court observation was. Yes, the Supreme Court said that auction purchaser challenged the judgment and the Madras High Court which was set aside auction sale. The SARFAESI Act is not mechanical compliance of a sale, but lawful realization of the secured asset. Then further the court said that there was a delay and statutory non-compliance by the borrower, and the delay was not due to the borrower action because there was no stay. On this, Supreme Court went further and said that ordinarily, very important to understand this, that ordinarily the right of auction purchaser, who is the bona fide purchaser, and due to confirmed sale, ordinarily they deserve protection. But such protection is not absolute. As per the Rule 9(4), the balance sale consideration must be paid within prescribed time, the subject to limited extension not exceeding 3 months. Now, in the present case, yes, the auction purchaser did pay entire amount, but the period taken was 15 months. Therefore, the Supreme Court confirmed the Madras High Court judgment that since it is not as per the bylaws of the SARFAESI Act, though bank has accepted the money and confirmed the sale, but that sale cannot be considered that legal, particularly when the borrower has also discharged the liability. So in that case, the Supreme Court set aside the sale and the property was given to borrower. Now, this is a very important judgment from the point of view that this type of situations arises in many of the cases. I'll give the citation. It's Supreme Court Civil Appellate Jurisdiction. It was out of the SLP 12331 and 12999 of 2023. Central Bank of India versus Sai International and others. Judgment is given by Justice Dipankar Datta Judge. And the matter is decided on 1st April 2026. Now, one should understand that the borrower should not get disheartened if the auction sale is confirmed, subject to going through the provisions of SARFAESI Act and the rules. So, in this case, borrower could get back the property. So, all the bankers also should take note of this, and any confusion, because the judgment is well considered judgment, so I don't want to give everything in detail on my YouTube channel, but anything is there. The bankers or the individual person who wants to know can definitely ask me. Any questions are there. So, but I just felt that this is very important judgment, particularly when I am handling around 22 banks. So that's why I uploaded this judgment. Thank you.